What happens if your executor can't do the job? Hi, I'm Neil Tyra, and I'm an estate planning attorney in Rockville, Maryland, and I do estate plans for regular folks like you and me. In other words, what if my executor can't serve in that capacity? A couple of weeks ago, we talked about what an executor really does. And this is more common and a more disruptive problem than most people realize. So when you create a will, you name an executor. Here in Maryland, we call that a personal representative. And that person is charged with the responsibility to carry out the wishes as stated in your will. But life happens, and that person may die before you, may become incapacitated, or move away, or decline the role, or simply be unable to serve for whatever reason when the time comes. So, what happens in that situation? What happens if your executor can't serve? Well, if your will only names one person and that person can't act, then you force the court to step in and appoint somebody. And that person may not be who you would have chosen. And it can cause delays or add some costs and create potentially family conflict. In Maryland, there's a statutory priority list, typically spouse, then children, etc. But that may not align with your intent. So, what do you do to avoid the problem? Well, typically, the best thing to do is to name at least one backup or successor personal representative, and maybe even two. And this ensures continuity and avoids court intervention. Secondly, you want to make sure that the person that you do choose is somebody who's willing and capable. You want to know that ahead of time. So ask them. So before naming them, ask them if they're willing to serve and consider their organizational skills, their availability, their temperament, and you also want to consider geographic proximity. I mean, if you're here on the East Coast and you appoint somebody on the West Coast, it's doable, but it's a little more cumbersome. Lastly, you want to consider carefully having co-executors. A lot of times we have parents who have two or more children and they want them to serve as co-personal representatives or co-executors. That's doable, but again, they must act together. They must agree on everything, and it can slow things down or even create potential for problems. So only use that when there's a clear benefit in doing so. And then lastly, review your choices periodically. Like the rest of your estate plan, is something that you need to review every couple of years or when major life changes occur. So what's the key takeaway? That it's naming an executor or a personal representative isn't a set it and forget it option. You want to have a backup plan and uh, trust that in doing so you can avoid unnecessary delays and costs and even disputes. If you want more information about the right choices for your personal representative in your will, our information is in the end of this video, and we'd love to have the chance to talk with you. Again, my name is Neil Tyra. I'm an estate planning attorney in Rockville, Maryland, and I do estate plans for regular folks like you and me.